So in that vein, do you think they're going to start taking more Second Amendment cases? And it's only been 2 years since Bruin. I know that's a long time for an average person. It seems like the court moves at a glacial pace, but that's pretty fast compared to the number of years it took between Heller and Bruin, right?
Well, right, and there were two reasons for that long delay. One is you had Heller in 2008, which says, yes, it's a real individual right. And of course, that includes sort of the most common typical application of the right, to have a handgun in your home. And then in 2010, they say, and that right is enforceable against the states by the 14th Amendment, which based on the court's precedents, was a very straightforward thing to do. And then after that, we go a long time without anything happening. And that is what the court watchers say is that on both sides, the four who were generally pro-Second Amendment, and then you had four who were anti it having any meaningful existence. And then you had Justice Kennedy in the middle, and both sides were scared of what he would do, so they didn't want to take a chance. Then you have Kennedy retiring. He gets replaced by Kavanaugh. But then, around 2020, when the court actually took a Second Amendment case from New York, involving New York City, and New York City at the last minute got rid of the rule, and Senator Blumenthal and others wrote a threat letter in the form of an amicus brief to the Supreme Court and said, if you decide this case, we're going to pack the court. And Chief Justice Roberts chickened out, and according to reporting by CNN, also convinced his colleagues not to take a number of other important Second Amendment cases for which cert petitions had been filed. So now we get to then when Justice Barrett joins the court, and that seems to have resulted in a court that is willing to do what Justice Thomas had been saying for a while, which is look how many Fourth Amendment cases we've taken in the past 5 years. Look how many First Amendment cases we've been taking, and we haven't been doing anything on the Second Amendment. And so we now seem to be moving to a more normal world where we'll get Second Amendment cases with more frequency. But we'll know a lot more about that next week after we see what happens to the cert petitions.
Right. Yeah. Because, although I guess the counterpoint is we only had one actual Second Amendment case. We had a couple of gun-related cases, but only one Second Amendment case this last session. So I don't know. I guess like you said,
if we can get one per term, that's a faster pace than we've been used to.
One every 14 years.
Yeah.
Right. Fair point. Now, we've gone through sort of what all the justices have been saying. I'm interested in what you think this is going to mean. We went from having not a lot of written words from the court on the Second Amendment to, I think it took, I don't know how many thousands of words are in this from the majority opinion, to be fair, I guess, is not super long. But there's a lot of concurrence. There's a lot more thought that the justices are putting down on paper on the Second Amendment now. Where do you think this all comes out in how the lower courts are going to approach the Second Amendment post-Rahimi?
Well, there's plenty of stuff in the anti-rights concurrences by Justice Sotomayor, joined by Kagan, and by Justice Jackson on her own for anti-rights courts to use. There's also plenty of good language from Justice Gorsuch's concurrence and also the Kavanaugh concurrence, which is the longest one. It talks about originalism and text history traditions and methodology, and Justice Barrett goes into that as well. So it'll keep lawyers busy finding stray phrases to pick out. But to the extent the courts are mainly focused on what the majority opinion says, which I think is it's exactly as long as it needs to be to make its straightforward case, that they are going to be a little more relaxed about upholding some gun laws on the margins, but they were re-instructed that Bruin is the right way to go about things.
Okay, interesting. So you still see this as overall a positive development for Bruin as a standard.
Oh, absolutely. It's a very important reaffirmation of Bruin as a standard, and not one of the justices of the 6 who voted for Bruin shows the slightest inclination to back away from it. So I think that it really solidifies that. Let's remember that from the pro Second Amendment point of view, this was inherently a terrible case, which is one of the reasons the Solicitor General brought it. The Solicitor General Prelogar is a very smart person, both at the level of the words you put in a particular brief, how to argue in front of the Supreme Court, and about litigation strategy. And so she knows there is no point, given the current court, of doing some frontal assault on Second Amendment rights. But when, from her point of view, you had the fortunate situation of the Fifth Circuit deciding the case in favor of Rahimi and holding 922G8 unconstitutional. She says, first of all, well, when federal statutes are held unconstitutional, that's the classic thing that we bring to the Supreme Court and ask them to reverse and say that the law isn't constitutional. Anything that meets that description I just gave has a very good chance of a cert grant. And then on top of it, in a Second Amendment context, Rahimi is so obviously the kind of person who shouldn't have a gun that it's a great factual situation. So from her point of view, this is, it's my job to defend this federal statute. And B, considering what a terrible guy Rahimi is, maybe we can convince the court to weaken its Second Amendment precedents without overturning them. And I think the good thing is, even if you would say, as Justice Thomas did, that Bruin was weakened, it was only in a very slight way, and Bruin's, in its general sense, is very much reaffirmed. So that this could have been much, much more damaging than it was, and I don't see this as a important problem for pro Second Amendment litigation going forward.